This may be one of the most important posts or videos that I have ever done in my entire life. This actually may be one of the most complex statements that I will make in terms of something outside of my capacity, but still very important to trucking, logistics, and everything as a whole. And it has to do with carriers in Canada and, respectively, some mentions of the USA carriers or trucking companies that are looking to get their unpaid invoices resolved. A lot of people can go through this situation and it could be a very stressful situation for them. And the fact that it's so stressful causes quality lapses in their service for their customers and their approach to customers in further doings in the industry. Okay. And this happens because they get a little bit reserved because they are afraid to get into a contract or a non binding contract with a freight broker or potentially even a direct shipper or doing some work for a consignee. The whole point of this video is to explain to you how you can go about resolving your payments even without going through a collections business. Okay? So, with the growing complexity of logistics transactions in the North America, carriers do often risk losing out on payment of freight charges. For example, if a freight broker goes bankrupt or otherwise decides to withhold payments, this could happen. And the US approach is a very much so principled policy that the carrier always gets paid. Under the US mercantile law, the US trucking company will always get paid, either from the shipper or the consignee, even if the shipper or the consignee has to pay twice. In other words, even if the shipper or the consignee paid the freight broker, they still have to pay the carrier if the freight broker failed to do so in the first place. Although the law in Canada is not so much straightforward, carriers do have a plethora of legal tools to collect on unpaid freight charges beyond just advancing a claim for breach of contract against the party by whom they were even retained. The legislation in some Canadian jurisdictions, or provinces if you would like to say, provides that where the contract of carriage is evidenced by a bill of lading, the carrier is given recourse to any named consignees or endorsees of that bill of lading. For example, the shipper or the freight broker, of course, in that situation. Even in situations that would typically be barred by the common law doctrine of privity of contract, in application, this means that a trucking company may be able to pursue payment from the shipper or the consignee in Canada, even if there is no contract between the carrier and that party directly. The Federal Bills of Lading Act applies to contracts of carriage coming within the constitutional competence of Parliament, like carriage by air, rail, sea, and even interprovincial trucking. In such cases, Section 2 of the Act establishes that every consignee or endorsee on a bill of lading who receives the goods covered by the bill of lading receives both the benefits and also the obligations of the contract it evidences. Accordingly, for contracts of carriage coming within the ambit of the Act, a carrier may have recourse to the consignee or the endorsee for any unpaid charges, even if such entities were not privy to the contract of carriage. In Ontario, the province of Ontario, Section 7 through 1 of the Provincial Mercantile Law Amendment Act contains wording almost identical to the federal legislation. However, the provincial legislation features a more expansive definition of bill of lading, which is good for carriers, which includes mere receipts for goods if they are accompanied by an undertaking to move those goods. Combined with the application of the Mercantile Amendment Act to areas within the constitutional competence of Ontario, Like trucking companies within the province, the Act has always been of great use to Ontario trucking companies seeking payment of unpaid freight charges. Carriers are in a particularly precarious position in cases where the entity responsible for paying the freight charges instead pays a third party. For example, the shipper or the consignee pays a freight broker. So, like a load broker, freight forwarder, if they pay those parties, who is then expected to remit the payment to the carrier. However, the agency law may permit the carrier to target the entity that forwarded the payment downstream, and in effect, forcing that entity, the shipper or the consignee, to actually pay twice. The relevant law in this area does come from the case of Canadian Pacific Ships versus Industries Leon Cordier. In this case, the Federal Court of Canada dealt with a scenario in which the plaintiff carrier sought payment from the defendant consignee for freight charges. The defendant consignee argued that it was not liable, as it had paid a third party load broker, freight broker, which it believed to be an agent of the plaintiff carrier. When the load broker went bankrupt within remitting payment, the plaintiff carrier sued the defendant consignee for the freight charges. So Canadian Pacific Ship sued Industries Lyon. Okay? Now, Justice Addy, who was the appointed justice for this, gave full judgment for the plaintiff carrier on the grounds that there was no basis for the defendant consignee to reasonably believe that the freight broker could receive payment on behalf of the carrier. And in effect, the defendant consignee was required to pay for the freight charges twice. And in resolving the dispute, the court held that in cases where a debtor pays a third party, instead of remitting the freight charges directly to the carrier, the responsibility lies on the debtor to show that one of the following is true to avoid paying a second time. So, for example, they have to prove that the carrier actually authorized the freight broker to receive money on their behalf. 2, the carrier held out the third party as so authorized. And 3, the carrier, by its conduct or otherwise, induced the debtor to come to that conclusion. Or a custom of the trade exists to the effect that in the particular trade and in those particular circumstances, both the trucking company or carrier and the debtor would normally expect the payment to be made to the third party. So in other words, the court is saying that the debtor, or for this case, the consignee, okay, has to prove in writing and by contract that the carrier hired this freight broker as an agent to represent the carrier, and in that case, the carrier is giving the freight broker full rights, legal responsibilities to accept a payment on behalf of the carrier. And who would do that? That makes no sense whatsoever. The reasoning in this Canada Pacific Ships case has since actually been applied to a lot of cases in Ontario, Alberta, British Columbia, and even in the Federal Court of Canada. And it stands as a warning to those who utilize the services of a carrier but funnel the payment of freight charges through a freight broker. Okay, do your due diligence of who you're sending your money to. In addition to this, the trust law also provides a mechanism for carriers to collect unpaid freight charges. Although the facts may support the imposition of an express trust over funds delivered to an intermediary for the benefit of a carrier, legislation may also impose a constructive trust in some situation. In Ontario, a useful statutory trust in this regard is established by Section 191-0-1 through 3 of the Highway Traffic Act. A person who arranges with an operator to carry the goods of another person for compensation by commercial motor vehicle shall hold any money received from the consignor or consignee of the goods in respect of the compensation owed to the operator in a trust account in trust for the operator until the money is paid to the operator. Although the statutory trust described applies to funds received by a freight broker who also retain the carrier, the assertion of the fiduciary relationship imposes strenuous equitable responsibilities in favor of carriers regarding the remission of freight charges. The effectiveness of the statutory trust claim is diminished in circumstances where the freight broker becomes insolvent or bankrupt. However, creative carriers should definitely be mindful of the Supreme Court's holding in the case of Air Canada versus M&L Travel, which gives rise to the possibility that directors of corporate trustees are liable in cases where failure to remit freight charges impressed by the statutory trust constitutes knowing assistance to fraud or breach of the trust by the directors. In the USA, freight brokers have to have a surety bond, and there have been additional things added to the surety bond status and how it is going to be dealt. As of January 16th this year, a new law has come out which will be enforced January 16th, 2025 in the USA that states that if a freight broker fails to pay a carrier and there's a bond filed, a claim filed on the bond against the freight broker, the freight broker will have 7 days to replenish once those funds have been claimed. 7 days to replenish that fund back up to the $75,000 minimum surety bond requirement. If they don't in those 7 days, they will then be forced to go through a second warning notice. And if they don't comply again, their actual authority will be revoked. Not just suspended, but also revoked. Okay? So this is very important. This may be one of the most important things I have ever said in this industry, and one of the most important videos you as a trucking company will ever watch. USA carriers have to also realize that the Canadian carriers have a lot of power based off of all these laws that I just mentioned. You as American carriers have even more say because of how strong the mercantile law favors carriers, that is trucking companies, in your cases. Don't be afraid to engage in contracts. The law is behind you. You just have to understand that, yes, you will win in 99.999% of cases because of this fact. I hope you like this video. Please give it a comment, a like, a share. We need to spread the news in the industry. And God bless to all truck drivers out there in both Canada, the United States, Mexico, respectively, as well, and the entire world. They move our universe around. Without them, we have absolutely nothing. The computer behind me, the mic in front of me, the shirt on my back, none of that would be possible if it wasn't for truck drivers. So thank you very much. I hope you enjoyed this video. And please note that this is for some hope for you out there, knowing that, yes, you definitely 100% will be useful to your operation, and knowing that this can be something that can be used for generations to come, as these applies hopefully through these applications and these laws hopefully will in the coming years become more strict and giving more and more power to the carriers in these type of unpaid freight invoice situations. Thank you very much for watching.